and welcome to tonight's panel event where we'll discuss the health and human rights considerations of the Queensland Abortion Bill, which is currently before our parliamentarians. Most of you know me, but if you don't, my name is Wendy Francis and I'm the Queensland State Director for the Australian Christian Lobby. I, along with many others, believe that the bill being considered would, if implemented, bring to Queensland the worst abortion laws in the world, allowing abortion to birth for any reason and with no allowance for conscientious objection. I do thank you all for attending tonight. It's very encouraging to have such a big crowd. There will no doubt be different opinions represented here tonight, and I want to just say from the outset that you are all very welcome. I feel confident that we will all show respect to one another in our attitudes and our behaviour. I'm going to introduce our panellists shortly, but can I first welcome members of Parliament who are with us tonight. These men and women will be voting on this bill on behalf of us. For the sake of time, I'd ask you to hold off your applause until right at the end of my acknowledgements. There were a number of MPs who were going to be here tonight and have not been able to come for one reason or another. One particular is that I'd like to mention is Jim Madden, the MP for Ipswich West. He was coming and he hasn't been able to come. But I do welcome Dr Mark Robinson, the MP for Cleveland, and his wife Julie. Dr Christian Rowan, the MP for Moggill. Ms Fiona Simpson, the MP for Maroochydore, and Mr Trevor Watts, MP for Toowoomba North. Thank you so much. Trevor's just walked in. I would also like to acknowledge tonight Julie Borgia, she's the President of Cherish Life. Alan Baker is here from Australian Family Association, and you can thank him for those Galaxy Poll brochures that you have. Juliette Ballinger is here, she's the coordinator for Eva's Place. Teresa Martin has been a hero in the pro-life movement for many years, and Teresa's here tonight. We thank her. Marilyn Rowsome is here from the Canberra Declaration. Kath Toomey is the Managing Director of Priceless House. I also want to make a special thank you to Andrew Smith from Pro-Life Media, who's donating his time and resources tonight to video this event, and so many others of you who have been involved in the Abortion Rethink campaign. Thank you so much. We're extremely privileged to have a high level of expertise on our panel tonight, and I'm going to briefly introduce them to you now, and then when a number of them speak, but also when they answer the questions, we won't introduce them at that stage, so I'll just introduce them to you now. Dr David Bartz is an obstetrician and gynaecologist who practices at the Royal Brisbane Women's Hospital. A few of our members of the panel are over here because they're going to speak up front, so I've put them in the corner at the moment, just to make sure they behave until they get up here. Marita de Jong is a registered midwife who graduated in 2006 and worked as an independent home birthing midwife in the Netherlands. She has been practising midwifery in Australia since 2010. Mark Fowler is a Brisbane lawyer with a focus on the not-for-profit and charity sectors. He's a member of the Queensland Law Society's Human Rights Working Group. Mark is currently a doctoral candidate at UQ, focusing on religious freedom and tax. He chairs Clear Australia, an international charity partnering with the developing world to progress the rule of law and human rights. Debbie Garrett is a registered nurse who holds 3 degrees as well as postgrad counselling qualifications and is currently undertaking her PhD on the issue of abortion. Debbie is founder and executive director of Real Choices Australia, a leader in research and education in areas of reproductive health, unintended pregnancy and mental health impacts of abortion on women. Dr Anthony Herbert is a Brisbane paediatrician who specialises in palliative care, with a particular interest in perinatal palliative care. Martin Niles completed his Bachelor of Law at UQ and is currently completing his Master of Law at ANU. He is the Director and Legal Counsel of the Human Rights Law Alliance, which exists to protect and promote fundamental human rights and freedoms in Australian law. Lucy Miranda works at Priceless House in Brisbane as a counsellor and psychotherapist in the area of crisis pregnancies, as well as post-abortive therapy. She has a degree in social science, majoring in counselling, and is currently completing a further postgraduate certificate in counselling. Rachel Wong is the Director of Research, Policy and Advocacy at Women's Forum Australia. She is a barrister, has provided pro bono legal assistance to women facing crisis pregnancies, and has recently worked with the Law Reform Commission in Samoa to bring about legislative reform to improve the lives of Samoan women and girls. She has a Master of Bioethics and Health Law from the University of Otago, with a dissertation on freedom of conscience in healthcare. Please welcome our panel tonight. I think you'll agree with me that we have a really eminent panel before us, and so it's going to be a really good night. Our program will begin with 4 of the panellists giving short addresses, after which I'll ask questions of our panel. During the evening, we're also going to hear stories of 2 young ladies, and time permitting, I will invite questions from the floor towards the end of the evening. So our first speaker for the night is Mark Fowler, and I would invite him to come up to the stage now, to the lectern now. Thank you, Mark.
Thank you, Wendy, for your kind introduction and the tireless work you do. The approach to abortion in the law must flow from consistent philosophical, ethical and scientific foundations and be based on fact. As the foundations accepted will do much to define the subsequent policy artifice erected, it is critical we consider the contesting truth and value claims in a reasoned and considered fashion. It was Aristotle who claimed that it is the mark of an educated mind to be able to entertain a thought without accepting it. In that spirit of inquiry, I recently attended a pro-choice event held in this room to hear the breadth of arguments asserted for decriminalisation of abortion. Perhaps my attention lapsed for a moment, but it struck me that during the course of the conversation between the assembled panel of experts, the question as to when life begins did not receive consideration at all. Those wishing to, in an Aristotelian sense, understand the pro-life position must begin with this most fundamental of considerations. Pro-lifers claim that abortion ends a human life. As recognised by pro-choice advocate Jeff McMahon, given the ramifications of this claim for the law, pro-choice supporters must surely have a considered certainty on the matter. He writes, "Although I defend the permissibility of abortion and thus welcome the introduction of the abortion pill, I do not believe the debate should end until we have the kind of intellectual and moral certainty about abortion that we have about slavery. It is important to notice that the ostensible victims of abortion are not parties to the debate, while of those who are involved in it, the only ones who have a significant personal interest or stake in the outcome are those who would benefit from the practice. There is therefore a danger that abortion could triumph in the political arena simply because it is favoured by self-interest and opposed only by ideals." End quote. If abortion entails the bringing to an end of a human life, we would be required to only permit it where there are greater prevailing moral claims causing us to do so. It seems to me that whether abortion does end a human life must be the starting place in the conversation. Its absence from the discussion at the recent pro-choice event held in this room seemed to me to rest as a very large proverbial elephant. On this question, my considered position is that from the time of conception, foundational elements of the personhood of an individual human being are present. Whilst the pre-birth child is yet to attain the personality aspects derived from what we often colloquially phrase as nurture, or from experience, they have from the moment of conception the genetic attributes that are associated with personhood. In this we might include whether they have dark or light hair, blue or brown eyes, a natural talent for sports, grandmother's longevity of life, dad's receding hair, or mum's left brain creative proclivities. We regard such aspects as being at the core of our individuality and of the individuality of those around us. It is surely a self-evident truth that the genetic traits that comprise our personhood today were present in the womb from the first moments of our conception. My position on this first question also draws on the fact that to delineate a developmental line in the gestational period where the child moves from non-human to human must be, to use the term given to philosophy's capital crime, arbitrary. That is, based on unjustifiable factors such as personal preference or opinion, as opposed to reason or fact. The two most significant moments in the child's development are conception and birth. Many developments are observed during the gestational period. At 5 weeks, 90% of the structures of the adult body are present. At 8 weeks, brain waves can be detected. At 12 weeks, the child resiles from pain. Where amongst gestational milestones do we in fact draw the line between human and non-human? Even one of the most famous pro-choice campaigners, Judith Jarvis Thompson, has stated that, quote, "I am inclined to agree that the prospects for drawing a line in the development of the fetus look dim. I am inclined to think also that we will probably have to agree that the fetus has already become a human person well before birth." Some offer a significant third moment as the first expression of human personhood, the development of consciousness in the years after birth. Consider the famous Australian Princeton bioethicist Peter Singer's justification of infanticide, which he makes on the basis that there is no moral distinction between the pre-birth and the post-birth child. To that extent, he is right. We would be wrong to dismiss Singer as a controversial outlier. He is merely honestly and sincerely extending the utilitarian pro-choice argument to its natural consequences. And as we turn from these philosophical and scientific underpinnings to consider the appropriate policy settings at law, whether we are dealing with life again remains the first question that must be considered. Given the possible odds at stake, being human lives, we should err on the side of caution. In the parliamentary inquiry held last week, much consideration was given to the question of whether the law has an educative role to play in society. Lord Devlin has, in the non-gender neutral language of his day, famously contended that society cannot live without morals. Its morals are those standards of conduct which the reasonable man approves. A man who concedes that morality is necessary to society must support the use of those instruments without which morality cannot be maintained. The two instruments are those of teaching and of enforcement, which is the law. The law does have an educative role. It communicates to the society of which it is a reflection the most important standards agreed in the compact amongst its members, and it communicates what those members value, the goods they uphold. We look to our legislators for leadership on matters where majoritarian consensus infringes on minority rights or imposes arbitrary prejudice against the vulnerable. The law is not an anchorless ship afloat in a sea of majoritarian consensus. In the inquiry proceedings held last week, discussion centred on the need to balance interests. Harvard Professor Michael Sandel recognises the profound challenge that the abortion debate presents to the modern liberal let and live mantra. He writes, "It is wrong to insist that the distinction between public and private morality can by itself decide the question. If abortion were to amount to infanticide, it would not be merely private choice. On that basis, the state has an interest in regulating the practice. Implicitly, this is recognised in the fact that all Australian jurisdictions except the ACT keep some element of the law of abortion within their applicable criminal code. Consider the words of Justice Maguire in The Crown against Bayliss and Cullen, which reflect the current law in Queensland. The law of the land has always held that human life is sacred, and the protection the law gives to human life, it extends also to the unborn child in the womb. The unborn child in the womb must not be destroyed unless the destruction of the child is for the preserving of the still more precious life of the mother. The current law in Queensland thus proceeds from the clear supposition that the child in the womb is a human life. The law must reflect back to the community that it both unites and embodies moral standards that are in true alignment with the intrinsic value of its members. We are resident in a world where technology has drawn us to practices that are so oppositional as to defy any basis and reason. In May, we discovered that children are being aborted alive and left to perish at 24 weeks of age in Queensland hospitals. In July, Queenslanders celebrated the success of an in utero operation performed by 5 specialty teams to save a child of equivalent age from spina bifida. The sole distinguishing factor between these children is the presence of another human being's desire for the child. It seems to me that the celebration in that operating theatre last month and the real tangible shock of our own Prime Minister when presented on Q&A with the numbers of children aborted and left to perish in Queensland hospitals more rightly accord with our moral intuitions than does the assertion that the fetus is not human and is not worthy of life. I consider that these uncritically accepted contradictions of reason cannot continue to hold in a society that seeks logical consistency in its law. The modern democratic representative's opiate is the attempt to balance interests in the search for a majoritarian consensus. In light of the philosophical and scientific imperatives I have outlined, it concerns me that such an exercise will prove deeply inadequate in acquitting the duties placed upon the law unless we recognise, as does the current law, the implications of the humanity of the pre-birth child. Thank you.
Thank you, Mark. Our next speaker tonight is Dr. David Bartz. Thank you, David.
Okay, so for the 5 minutes I'll try and keep this quite brief for you. So I've been a doctor for 34 years, and for 28 of that years an obstetrician gynaecologist. I work at Royal Brisbane Women's Hospital, so I've got a vast experience, both medically and psychologically. So I'm not going to tell you academia. I'll leave that to others who will fluently talk about that. But what I can bring you is some clinical perspectives on it. And it's my strong conviction that abortion is a trauma. It's a trauma to babies, to mothers, to fathers, to families, to society. And what is that trauma? There's physical trauma, but there's also quite profound psychological trauma. And coming from a clinician, I might start on the psychological side. Mind you, it's the only thing I never did a term as a resident with psychiatry, but here we go. And we've all heard of the association of psychological factors, depression, etc., around abortion. Figures vary so widely, figures are so hard to get. I'd noticed for years women with abortion, who have had abortion, it seems to so often lead to that regret factor, that little factor that's not mentioned, that pregnancy that's not mentioned to you when you're seeing that woman, that a hysterectomy you're doing when the woman breaks down a few days later and it comes out she had an abortion when she was 16 but never told anyone. And I remember 10 years ago when I presented some figures on some of the medical problems happening, and you remember at the time there was a lot of these late-term abortions going on in Queensland at a clinic near the Royal Brisbane. And that was good, that was near Royal Brisbane, because it wasn't far for the ambulance to get them down. And I remember one 17-year-old girl coming down with a loop of bowel between her legs, and the psychological trauma on that girl was quite extreme. And I remember obtaining a copy of the Planned Parenthood of Australia's consent form for these procedures at the time. And interesting, it had suicide on it. I said, that's very interesting. They're acknowledging this. And then very lately, June 2016, the maternal and perinatal mortality and morbidity in Queensland figures came out. June 2016, last month. So I said, okay, I'll peruse through that, not knowing what I would see. So let me read you a few figures here. The most common cause of maternal death is, it's not hemorrhage, it's not infection, it's not preeclampsia, it's psychosocial. They've got suicide, homicide, substance abuse, etc. And it goes on to comment, this is an expert panel. It is concerning to note that suicide was and continues to be the leading cause of death in women during pregnancy and within 365 days of the end of pregnancy. Isn't that extraordinary? Suicide. We believe that the reported number of mothers who suicide in association with pregnancy is underestimated and is actually greater than is counted in these figures, as there is a lack of available information regarding the number of miscarriages and terminations of pregnancy in Queensland. It is essential that we identify pregnant women and new mothers who might benefit from appropriate care from mental health professionals. And it is particularly important that we show a greater appreciation for the potential for depression and other mental health issues, particularly in association with the termination of pregnancy. Not my words, that's an expert panel. Practitioners referring women for termination of pregnancy or undertaking termination of pregnancy need to ensure adequate follow-up for these women, especially if the procedure is undertaken due to mental health concerns. Now, I can tell you about a lady, and you, being a clinician, you want to hear the clinical perspective on it. I can tell you many stories, but I'll tell you one that's quite profound, that left a profound mark on my memory. A woman who conceived from rape here in Brisbane. And I caught up with this woman in the early pregnancy. It must have been about 15, 16 weeks, and she was severely traumatised. I mean, rape is a trauma. And she was on antidepressants, and she had seen a psychiatrist. I can't say whether there was pressure on her, but it seems to me she was feeling there was a lot of pressure on her to have a termination, as if this is the solution to everything. And I didn't impose my will. I let this woman talk, but the longer she talked, the more I reinforced her. And she carried that pregnancy, and I delivered her at 38 weeks, beautiful little baby. And she said to me during that pregnancy that she didn't want to add to the trauma of the abortion, she didn't want to add to the trauma of that rape, the trauma of an abortion. Think about that a little bit. This is an extreme case. Nothing takes away the trauma of that rape. And an abortion certainly does not take away that trauma. This woman said it would have added to her trauma. To add to the trauma of the rape, the trauma of an abortion. That's quite profound. Now, this woman continued to see me yearly with no specific complaints, but she wanted to see me. In particular, she wanted to bring up her little child, who would bring a little donut for me each time, which was very nice. And this woman continued to suffer with psychological problems, but less and less. And she said to me, look, despite all this depression, the one thing that has kept me going is my child. So the notion that somehow an abortion takes away mental health issues, I believe is a complete fallacy. And around this you can say, did an abortion in general happen because of psychological problems and they were difficult and had an abortion? Or did the abortion lead to depression? There's probably both factors involved in different cases. Some women are having mental issues and psychosocial issues, etc., and consider, I can't carry this pregnant, etc. But some women, but however, the question is, does having that abortion in that woman improve things for her or make it worse? I have a strong conviction it makes it worse. And this little girl that would come every year, a beautiful little girl, and you look at her and you say, if she had the chance to say, Mummy, thank you for carrying me, and that has kept her going, that mother, who was still single when I was seeing her. She was about 6 years old at that stage. But it was the fact of carrying that pregnancy and that child that has turned things around in her life rather than made things worse. And unfortunately, look, you can't convince people, and everyone have their views, but I have a strong conviction that whether there is a pre-existing mental health issues or not, the abortion on top of that makes it worse. All right? And they're highlighting the risk of suicide now. It's the leading cause of maternal death in women now in Queensland. So let me go on to, now you probably want to hear a bit of the physical, but, years ago, I was at Royal Brisbane, I was seeing so many problems happening that I brought it to the attention of people, and it got to the attention of the newspapers, and particularly what they used to call the D&E, dilatation and extraction, or late-term abortion, where See, an abortion, usually under 13 weeks, it's done by the suction curettage, like miscarriage type thing. As the pregnancy gets further, that becomes riskier. And you remember the Dr. David Grundman and all the dilatation extraction things. And they were doing them at the clinic there, and we were seeing terrible problems with it. We were seeing perforated uterus. I told you about the loop of bowel between the lady's legs. Hysterectomies, I saw perforated bladders, I saw perforated ovaries, ureters, lots of things. Numerous hysterectomies, which are still going on. And so I brought that to the attention, but the political will wasn't there to sort of listen to it. Correct me if I'm wrong, but that practitioner, I think, moved his services to Victoria, where they had liberalised abortion rules down there. So we weren't seeing as many problems from that clinic, but my colleagues on the south side of Brisbane are seeing problems come through from other clinics at their hospital that even recently they're telling me about. Obviously, the later that pregnancy goes, the more the risk. And when pregnancies are aborted or terminated later, these 26 weeks, they're not done by a D&D thing. It's like a pregnancy induction thing, unfortunately, we're in a society where adoption is given a bad name, I can tell you, oh God, I could talk forever, but I see so many infertile couples. And the average age of marriage in Queensland, Australia is about 31 for a woman, I think. I see so many 39-year-olds and 41-year-olds with severe endometriosis and, you do everything you can in infertility, desperate for children. And, women at that age, and a lot of them might go for IVF, but the success rates are very low. They would give anything to adopt a child. And I think a child would give anything to be adopted by loving parents. So, look, I've been given the bell. I thought I was only going to talk for 2 or 3 minutes, but so that was just a little bit of background for you. Thank you.
Thank you. I'm now going to welcome up Rachel Wong. Thank you, Rachel.
Shortcut. Good evening, everyone. Thank you, Wendy, and the Australian Christian Lobby for the opportunity to speak to you all this evening. For those of you who are not familiar with Women's Forum Australia, we are an independent think tank established in 2005. We strive to be a powerful and positive voice for women by promoting the dignity of women and their unique and critical role in society through research, education, mentoring and advocacy. Especially unique to women and critical to the flourishing of our society is women's role in the nurturing of human life. Mr. Pine's bill is being touted as promoting women's health and women's rights. However, Women's Forum is of the view that legislating for abortion on demand is counterproductive to both. We believe this is particularly so for 3 reasons. Firstly, the bill proposes no regulation of abortion on demand, with no recognition of the significance of this decision for women or the risks of physical and psychological harm inherent in abortion. Secondly, the bill includes no safeguards to ensure that women are giving fully informed consent. Such safeguards are critical for women to make a real choice when it comes to abortion. Thirdly, the bill makes no attempt to understand and address the societal issues which might make women view abortion as being their only choice. By simply providing women with the so-called choice of abortion on demand, the more difficult question of why women choose to have an abortion and actually providing them with the support they need to make a real choice is effectively avoided. While Mr. Pine's bill is a wholly inadequate attempt to legislate on such a complex and sensitive issue, it has opened up a conversation which, if we allow it to, could pave the way for truly pro-women reform in this area. In this regard, Women's Forum believes that any reform of abortion law must include key features including: firstly, any reform must include research into the harms of abortion, which should inform any legislative or policy changes in this area. Such research should be made available to women, generally and when faced with an unplanned pregnancy. Secondly, any reform should include legally mandated informed consent requirements for women considering an abortion, such as prescribed information to be provided to women considering an abortion, including information about fetal development, the health risks of abortion, and alternatives to abortion. Offering women the opportunity to undergo an ultrasound prior to making a decision. Imposing a mandatory waiting period before the abortion is performed. And requiring women to access counselling, which is independent of abortion providers. Thirdly, any reform should include research into the reasons women choose abortion and the support of real choice for women by addressing any societal barriers that might otherwise lead women to believe that they have no choice other than to terminate their pregnancy. This includes urgently progressing real alternatives for women facing unplanned pregnancies, including much-needed adoption law reform, and addressing issues of domestic violence, access and affordability of childcare, incentives for flexible workplace and study arrangements, and access to pregnancy counselling and psychological support. Finally, and perhaps prior to any other reform, it is imperative that data and information regarding the practice of abortion in Queensland is collected and made publicly available so as to inform and properly direct any changes in this area. From reading the written and oral submissions on both sides of the bill, the dire need for data collection in this area is something that almost everyone agrees on. To genuinely promote women's health and rights and to provide real choice for women, Women's Forum strongly believes that any legislative or policy changes must take into account and directly address the harmful impact of abortion on women's health, the current lack of informed consent, and the underlying reasons women choose to terminate their pregnancies in Australia, coupled with the appropriate support for these women. We need to provide our women with more information and more support, not more abortion. If changes are to be made, they should be directed at addressing these pressing issues, rather than exacerbating an already flawed system by legislating for abortion on demand. The bill in its current form has not been properly thought through. On such a sensitive and complex women's issue, it is critical that any changes be evidence-based and be shown to benefit women. We believe that women deserve better.
Thank you so much, Rachel. And our last speaker for tonight is Debbie Garrett. Thank you, Debbie.
It's a big step down. Thanks so much, Wendy and the ACL, for the opportunity. It's so nice to see so many familiar faces I haven't seen for a long time. So thank you for the opportunity to speak to you in my capacity as a researcher, counsellor and educator of more than 2 decades to give a voice to the many hundreds of post-abortive men and women that I've spoken to during that time. It's timely that we're having this discussion on abortion and the way in which its current availability impacts women. It's unfortunate that we're having the wrong discussion about that, one that's not based on the best available evidence, but on ideological misinformation. This doesn't serve women or our community. There is clear and unequivocal evidence that up to 20% of women suffer measurable, serious and prolonged mental health adverse effects after abortion, including increases in depression, anxiety and suicide. Many of these women cope with these kinds of emotional issues with significant increases in alcohol and drug use. While some dismiss this 20% as an irrelevant minority, when we're talking about 80,000 abortions annually, this equates to around 16,000 women each and every year being measurably harmed. The cumulative effect on families, communities and the economy are enormous, but unlikely to ever be accurately determined because of the silence and stigma that surrounds abortion, particularly abortion harm. This 20% doesn't include the even higher percentage of women and men who are forced to live with ongoing grief and regret that doesn't meet a measurable mental health outcome, but which can be very debilitating. We know there are specific risk factors to predict mental health harm to women. These include being young, whether a teen or young adult, being unsure about the abortion decision, making a decision in conflict with your personal values, feeling coerced or pressured by people or circumstances, feeling a sense of connection to your unborn or believing that the unborn is a human being, having pre-existing mental health problems, immaturity, emotional instability, high anxiety, difficulty coping, or being in a conflicted, unsupportive or abusive relationship. With 95% of all abortions being undertaken for psychosocial reasons, most women fit one of these categories. For the most part, these women are physically and mentally healthy and undergoing a procedure for which there is no evidence of health benefit. If other elective or unnecessary surgical or medical procedures in these kinds of numbers were being undertaken on healthy women experiencing pressure with no risk factor screening and resulting in this level of adverse effect, we'd be banning it, not making it less restrictive. Instead of promoting abortion as a solution to domestic violence, we should be discussing how better to support women to leave violent relationships and how to ensure violent men don't intrude on their future relationships. Instead of promoting abortion as a solution for young women who want to finish their education, not tell their parents they're pregnant, or are just embarking on a career, we need to enact and enforce laws that ensure that pregnant and parenting women will not be discriminated against and will be practically supported in educational and professional sectors. Instead of telling women that abortion is the solution to their housing problems, their financial problems, their mental health problems, all of which are risk factors predisposing a woman to abortion harm, we should be creating communities where women can be supported and nurtured into parenthood. Instead of being reactive to ideology and enacting legislation based on the misinformation that women are having trouble accessing abortion, we should be worrying about why women are not being effectively screened for risk factors or coercion, nor offered genuine supportive alternatives. What is being proposed in this bill is not a progressive step on this issue. In the USA, where I do a fair bit of work, the majority of states are legislating greater restrictions around abortion in light of the growing evidence of harm, including waiting periods, mandatory counselling, parental consent and notification. Yet we continue to move in the opposite direction, pressured by a vocal, misleading, ideological minority. In 2008, Victoria enacted what's currently some of the most liberal abortion laws in the Western world. These laws have had no impact on what abortion advocates misleadingly state are the issues. They state that women need better access and that this is prevented by the current state of the law. This is not true. There are no more doctors performing abortions and there is no more greater access for women. And even the most cursory perusal of social media confirms that the majority of women have no problems accessing abortion here in Queensland either, and they're unaware that there are even legal issues surrounding it. The laws have, in Victoria, now ensured that women have less recourse to legal support if they're not appropriately screened or if they are harmed. The law has restricted doctors from talking to their own patients about the potential of harm if they don't wish to refer their patient for abortion for any reason, even if what they believe that their patient is at higher risk of harm. This means women are less informed, not more informed. My current PhD research is discovering that for many practitioners of many types, talking about abortion is severely hampered by ideological concerns, often based on misinformation. Women are less likely to be offered alternatives or support when the only place they source information is from an abortion provider who has a vested interest in the abortion taking place. The wider availability of medical abortion is highlighting the coercive nature of abortion from both women's circumstances and from within the clinics themselves. I delivered a paper on case studies of coercion within Australian abortion clinics at a recent international medical conference. The following are quotes from two of the women whose cases I presented. Both sought medical abortion in clinics in 2015. So this is what's happening in our clinics today. The first woman said, "I said I wasn't sure, and the doctor told me to take the pill or get out. So I took it." And the other woman, "I had the tablet in my mouth and I was crying and saying I didn't want to swallow it. He said you can hardly bring a baby into the world when you so obviously don't want or love it. I was horrified and devastated. I swallowed the pill." I hear from an average of 2 women a month like these women, desperately seeking to reverse a medical abortion they began, lacking support and terribly misinformed. These are the issues that should be discussed and addressed. Women are being coerced by people, by circumstances, by discriminatory practices, and by abortion providers to undertake abortions they don't want and don't need. They are then sold these practices as the only means to achieve autonomy and freedom. In Victoria for the last decade, around half of all late-term abortions, that's post-20-week abortions, have been undertaken for psychosocial reasons. Women undergoing late-term abortions have a significantly higher risk of psychological and physical harm. Women whose unborn babies are diagnosed with congenital abnormalities or even suspected of having such abnormalities tell of being greatly pressured toward abortion, using the very compassion and nurture they instinctively feel toward their unborn children against them. They are told that termination is the compassionate, loving and best thing to do. We don't tell them that their grief will be more complex, their risk of psychological harm increased, and that they will be silenced because of their part in the decision-making process. They are rarely offered an alternative, as there are only a handful of perinatal hospice units in our country. In 2010-2011 in Victoria, 18 babies were aborted after 28 weeks, with one of these being after 37 weeks, all for psychosocial indicators. Healthy babies of healthy mothers. This cannot be the best we can do for women. The discussion we need begins with how it is that we allowed an ideology to drive us to this point where we have no regard for our own humanity, no regard for the real experiences of women. This is an ideology that is betraying women and betraying all of us. Thank you.
Thank you very much, Debbie. Thank you to all of you. And I appreciate each one of you on the panel being prepared to answer some questions for us now. This is an incredibly important issue, and I don't know about you, but I sit there actually feeling quite ill at times. It's a difficult issue. There's no winners here. My first question tonight is addressed to Mark Fowler. Now we've got 2 microphones. Is that one working, darling? No, we do have 2 microphones, but one doesn't work, so that's not helpful, is it? But we've got one then. So my first is going to be to Mark. Just make sure. Yeah. Hello. Just took a woman.
Conceded.
Mark, can you explain to us what the current legal status in Queensland is in regards to abortion? I think that's a good place to start.
Okay. So permit me, I'm one of the lawyers in the room, so I will be slightly forensic about this. And for all that can be said about the law, it's certainly not necessarily salacious or a read of the new idea. There are some dry elements to the law, so please bear with me. But I think, as Wendy said, it's important to start from what we've currently got as the law. And so some of this, the best way to explain the law oftentimes is to work from the facts and then look at how that moves into the law. So anyway, as probably is well known, but as was just said a moment ago, not well known in the community, abortion is regulated under the Criminal Code in Queensland. Section 224 of the Criminal Code says any person who with intent to procure the miscarriage of a woman, whether she is or is not with child, unlawfully administers to her or causes her to take any poison or other noxious thing, or uses any force, so incorporating surgery, is guilty of a crime. So that's 224. 225 criminalises the mother in similar terms. 226 criminalises any person who supplies or assists in that type of an arrangement, assists a woman in performing an abortion. Section 282 provides the defence to Section 224, and that's the defence that applies to medical practitioners. And I'll set out the elements of it because it's important that we understand it. So, if the medical treatment is applied in good faith, with reasonable care and skill, and it is to preserve the mother's life, and performing the operation or providing the medical treatment is reasonable, having regard to the circumstances of the case, is the legislation. So that's then moved into the world of judicial interpretation, and I'm going to take you through some of the key judgments. The first of the judgments is the Crown against Bourne, a 1931 UK decision, which has been cited in the lead Queensland decision here. The facts of the case were a 14-year-old girl who'd been raped by 5 soldiers. And I'm going to quote, the best way to do this accurately is to quote directly from the judgments. So this is what Justice McNaughton said. The law of the land has always held that human life is sacred, and the protection the law gives to human life, it extends also to the unborn child in the womb. The unborn child in the womb must not be destroyed unless the destruction of the child is for preserving the still more precious life of the mother. Some there may be who hold the view that the fact that a woman desires the operation to be performed is a sufficient justification for it. Well, that is not the law. On the other hand, there are people who, from what are said to be religious reasons, object to the operation being performed under any circumstances. That is not the law either. So he gives an example of such a religious objection as one where the life of the woman could be saved by performing the operation, and the doctor refused to perform it because of his religious opinions, and the woman died. He says that I mention these two extremes merely to show that the law lies between them. It permits termination for the purpose of preserving the life of the mother, which is what Section 282 reflects. He then goes on and says, ultimately, if the doctor is of opinion on reasonable grounds and with adequate knowledge that the probable consequence of the continuance of the pregnancy will be to make the woman a physical or mental wreck, the jury are quite entitled to take the view that the doctor is operating for the purpose of preserving the life of the mother. So we've got to remember that most of these judgments are directions by a judge to a jury, and the jury makes the decision in light of the facts and the evidence that's been put before them. So this is a judge's outlining of what the applicable law is. He then goes on to say that it must be injurious to a girl that she should go through a state of pregnancy and finally of labour when she is of tender years, being 14 in that case. And the mental effect produced by a pregnancy brought about by this terrible rape must be prejudicial. So that were his directions in 1939 of the jury, and the jury acquitted the doctor in that case. Then we move to Queensland law, and the lead judgment is a judgment by Justice Maguire, which I referred to in my opening remarks, the Crown against Bayliss and Cullen. So he relied upon the Bourne precedent I just outlined and said that cannot be made the excuse for every inconvenient conception. It would be wrong to conclude that Bourne equates to carte blanche. It does not, On the contrary, it is only in exceptional cases that the doctrine can lawfully apply. This must be clearly understood. The law in this state has not abdicated its responsibility as guardian of the silent innocence of the unborn. It should rightly use its authority to see that abortion on whim or caprice does not insidiously filter our society. There is no legal justification for abortion on demand. So that's his statement of the current law, and that is still good law. Relying on a couple of other judgments from other Australian jurisdictions, he set out the test as this, again, that the exception will apply in only exceptional cases where it is carried out in good faith with an honest belief that to avoid serious dangers to the mother's life or her physical or mental health, not merely the normal dangers of pregnancy and childbirth, which the continuation of the pregnancy would entail, and in the circumstances it's not out of proportion to the danger to be averted. He also said this to give a bit of an indicia as to the kind of terms that have been applied in the various judgments that he was citing. He said this: "My research into the case and statutory law on the subject reveals that the following qualifying words and phrases have been used in relation to the danger and health to the mother. Serious, permanent, grave, serious and permanent, grave and permanent, grave and irreparable, serious prejudice, grave permanent prejudice, real and substantial, real or substantial." So that's the lead judgment in Queensland from 1986. So you can see that there is as I pointed out earlier, that there is a recognition of the sanctity of life, that the child itself, the unborn child, is a human child, and that the criminal law will apply protections to that child. Again, in Bayliss' case, it was then referred to a jury. So they were the directions I just read to you, and the jury did not convict. They acquitted the doctors in that particular case. Moving a little more to recent times, many of you would know the 2009 case involving a young couple where the male partner had sought, I think, RU486 and another drug overseas, and the mother then took that drug. The direction that was given by the judge to the jury, and I should say Section 225 was enlivened, so the mother's the penalty applies to the mother, and he said that in order for the jury to find the mother guilty, they had to find that the drug was administered with the intent to harm her and not just the fetus, and they found that that was not the case, and so she was acquitted. The recent case, which has really prompted this effort at reform, is the Q case, Justice McMeekin. The facts in that case concerned a 12-year-old girl, and this is the girl had attempted suicide and was self-harming, and the judge said this. So an application was made to the court because although the parents consented, the hospital consented, or the doctors consented, it was felt that there was a need to get a court order. And so the court looked long and hard as to whether or not the child had formed a sufficient level of consent and understanding, and found that she had. And the court said this: "There are strong grounds to believe that Q, who is the child, is at risk of suffering psychological harm and serious harm. There is good reason to think that she is at considerable risk of physical harm as well." So the court then allowed the abortion to proceed. So that was the recent case this year. And then I might just make a few brief comments without stealing Martin's thunder, but human rights law does apply to Queensland law by Article 50 of the International Covenant on Civil and Political Rights. And oftentimes, you may have heard, human rights law is cited as an authority in support of abortion. But it's key to just set out a few rudimentary facts, and then Martin will expand on this, I think, later. No global UN treaty contains the word abortion. There is no right to abortion that can be inferred by any treaty's terms. In fact, the closest we get, one of the references, is in Article 6.2 of the International Covenant on Civil and Political Rights, to which Australia is a signatory, and which contains a provision that federated states within a signatory must apply these laws. So it comes through to Queensland on that basis. It says, "Sentence of death shall not be carried out on a pregnant woman." So it infers the presence of the child, the existence of the child in international law itself. Further, the Convention on the Rights of the Child states that the child, by reason of its physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. So the Convention on the Rights of the Child recognises the child. There are some UN committees as opposed to courts. The UN doesn't maintain courts, but they maintain these quasi-judicial bodies. And two of those bodies have upheld a woman's right to abortion. When you look closely at the circumstances, it is informative to the kind of matters we're talking about. So they include a mentally impaired woman who sought an abortion after a suspected rape by her uncle, a woman impregnated by rape seeking abortion to allow surgery to prevent severe spinal cord injuries, abortion sought where the child was anencephalactic, a fetus with trisomy 18 which would die in utero or shortly after the birth. So they're the main leading judgments that have come out of the UN. You can see the extremely limited circumstances in which it's being applied in international law. And look, the final thing to note in the law, it's interesting, we've got a conversation that's going on in Queensland at the moment about implementing a human rights charter. If you look closely at the terms of the Victorian Human Rights Charter, you'll find this exclusion. Nothing in this charter affects any law applicable to abortion or child destruction. The implication behind that is that there are human rights at play, and one of the most obvious human rights there on the authorities I've just cited from Queensland and elsewhere is the right of the unborn child. Thanks.
Thank you, Mark. I'm going to direct my next question to Dr. Herbert. Anthony, can you tell us what palliative care is currently offered to late-term babies that are born alive? And how do you approach a bad diagnosis for a baby in the womb from the baby's point of view and also the parents?
Okay, so obviously meeting the family at a difficult time when they've had a diagnosis of a life-threatening or life-limiting condition during pregnancy. That's often detected on the 18 or 20-week ultrasound, which sort of is able to visualise the baby very well, and various conditions can be diagnosed at that stage. I guess in terms of perinatal palliative care, we're trying to meet the family at a difficult time in a non-judgmental and compassionate way. I guess giving another option to abortion, which is to continue the pregnancy to natural delivery. And I guess our focus would be on supporting the mother, also the father if they're part of the family, and then sort of working through a delivery plan for the baby, which would include sort of standard cares of how we would deliver a baby, but other aspects such as when the baby's born, I guess most importantly giving the baby tender loving care and the ability of the chance for the mother to hold and cuddle the baby, but also to treat any pain or distress that the baby may be experiencing. We aim to neither shorten the baby's life, but also not to prolong the baby's suffering. Some babies only live for a very short time, and so the seconds of their life are very valued. Other babies live much longer than expected, and there are some patients, for example, with trisomy 18, which Mark mentioned, who live beyond the age of 1, some who live beyond the age of 10. So I guess we'll support the family for as long as is required. And I guess it's really the baby that's determining the child is determining how long they're going to live for based on their sort of the severity of their condition. Other aspects of care include, I guess, meeting the spiritual needs of the family, which may relate to religious rituals, whether that's a baptism, dedication, naming ceremony, cultural aspects of care, and also, I guess, helping families to, I guess, make as many memories as they can of the short life that of the baby that they often dearly love. And I guess, although it's a very difficult situation, having a baby die in the first few hours, days or weeks of life, I guess the families cherish the chance to meet that baby and I guess integrate the living memory of that baby into the rest of their family life. It's also critical to support the brothers and sisters within that family as well.
You may have already answered this, but I was just going to have a further question. What are the moral and philosophical issues that are involved here?
I think I guess when you look at sort of modern bioethics, there's the one principle is the sanctity of life, or as Mark has said, human life is sacred. And that's an approach to ethics that's sometimes called the deontological approach. And then I guess a more modern approach to ethics, which is sometimes referred as the utilitarian approach, focuses more on the autonomy of the patient to determine, I guess, what happens to them in terms of medical care. So I might go back, I guess, so how to think morally about early human life or the unborn child in the womb. I guess the challenge is that the fetus develops in a woman, so I guess we're dealing with both, I guess potentially two patients, the mother and the baby, and I guess rather than trying to focus on one or the other, perhaps it's good to try and get the best outcome for both mother and child. So it really comes down to the moral status of the fetus, and there are moral restrictions on killing something for our own purposes, which are grounded in the nature of the creature, so that if a living organism has moral status, then we can't kill that organism for our own purpose. So I guess in terms of does an embryo have moral status? Well, certainly it has the potential to become a human and have a future life like ours. And secondly, I guess all human life has dignity, and I guess you can sort of argue that life is a continuum from conception through the stage of embryo, then through the fetal stage to birth. And the right to life or dignity is the most fundamental right a creature can have. And if a creature has that right, it must be in virtue of that, that the creature I guess has a moral status. And so I guess we would argue that both the embryo and the fetus are stages in the life of the individual human being and therefore has dignity. And we would also argue, even if that individual had some disability, that there's still dignity within that life. So I guess that's the moral status of the child in the womb. The theories can sort of, I guess, develop a little bit more in terms of what's sometimes called sentience, which is arguing that moral status is about the protecting a creature's interests based on their ability to be aware of their surroundings. And I guess it's argued that probably around halfway through gestation, so around about the 20-week mark, there is some awareness of surroundings, and so hence I guess we particularly are arguing against late-term abortions. Some would argue that there's a gradual development of moral status throughout the pregnancy. Again, this would argue strongly against late-term abortions. And finally, I guess there's also the counter-argument, which is the permissive view of abortion. And I guess without necessarily getting into the details of that, really focuses on the autonomy of the mother, I guess, in determining, I guess, her rights over her body and reproductive life. So.
Anthony, thank you. And thank you on behalf of all of us for what you do. It's an honourable thing that you do. And to have two doctors here from birth and then to death, I just find that extremely impressive. So thank you so much, both of you. I've had two sisters die. Yep. I've lost two sisters, and the palliative care medical staff that cared for them was just second to none. And so I know a bit of what you would be offering. So thank you. Luci, I'm going to move to you now, if that's okay. Luci, is this just a concern? I get this a lot, but is this just a concern for religious people? Is it only religious people that are opposed to this Pine Bill? And if not, Or if it is, yes, but if not, are there any non-religious reasons for concern? You see a lot of women. Yeah.
Sure. Thank you for your question, Wendy. To say that abortion is a concern only for religious people is a misconception. Abortion is often described as a woman's right to her own reproductive choices. But what is missed in the narrative is that the baby also has a right to life. And as it's been already discussed here, there are many articles in, for example, the Universal Declaration of Human Rights, and as well as the Article 6 of International Covenant on Civil and Political Rights, which, and I'll quote, it says that every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of this life. So it's actually a question about humanity. It's not a question about religion. It's about actually identifying and giving the dignity that a human person has inherently, because we are human. The loophole for many is the ambiguity of the question, when does human life begin? These days, there is plenty of medical advances telling us that by the time the first trimester is over, all of major organs are functioning in uterus, and there's brain waves that are detected at 6 weeks of life. The kidney seems to be working quite okay, and by definition, this makes a human or the fetus a living organism. As well as that, the human condition is universal. People in Australia, in America, Paris, everywhere in the world, we all are conceived the same way, through a sperm and an egg. We all share the same experiences and characteristics that actually make us human. We all are vulnerable to disappointments and tragedies in life. We all love, we hate, we laugh, we cry. And thus far in human history, every generation has experienced everything that I've mentioned. The right to life is inherently human, and it's common to all regardless of creed. So the question is not about religious affiliation, but it's more to do with the humanity that we give to the baby. And in our practice, we actually see that a lot of women that actually struggle post-abortion due to the trauma and what's actually happened, once they came to the realization that they have actually terminated a life, is that a lot of them don't have religious affiliation. They don't belong to any organizational religious at all. They just do not, that's not in their being. However, they do know that something was broken in the process of the abortion, and they have no religious affiliation at all. But they have actually agreed that there was life there.
Thank you. I said at the beginning of the night we're going to hear a couple of stories. Just like to ask Madeline Weideman to come up to the lectern at the moment and give us her story. Thank you so much, Madeline, for being prepared to come tonight.
Thank you very much. Mine is a story of abortion regret. I accidentally got pregnant at 18, and in the midst of confusion and shock, I chose to have an abortion. But I'm not sure it was choice, to be honest, because no other options were really given me. I wasn't overtly coerced or threatened, but I was certainly not empowered to make an informed decision. When I saw a doctor to have my pregnancy confirmed, I told her that I planned to have an abortion in that very short appointment. I was given a number to call, but there was no discussion about other options or potential risks. That was not a choice. I was counselled at the clinic on the day of my abortion, asked if I had concerns, but when I expressed fears, I was told they were totally unfounded. I was told the fetus was only a ball of cells, no bigger than the size of half my little fingernail. But that's not true. Several years later, while studying anatomy and physiology, I was shocked to learn that at 8 weeks pregnant when I aborted, the baby would have been 3 centimetres long, and every organ functioning, its heart beating. Therefore, what I was told was wrong, and the discovery horrified me. I've heard other women recall the exact same language used in their pre-abortion counselling. This is not empowered, informed consent, nor unbiased counselling to help women make choices of reproductive freedom. After the abortion, I was given a pamphlet to take home. It said that because of hormones, I may experience several days of heightened emotions, but no further grief. So when I began to feel sadness, I felt I couldn't possibly go to that clinic because there was no room for my experience there. I was disenfranchised, as if my right to experience regret was not permitted. And I suffered years of depression and anxiety and struggled with postnatal depression, struggling to connect with my children who I'd later given birth to. For years, I didn't identify the cause of this distress. I was not counselled well, and I was not prepared for what would come. It wasn't until after I identified the false information I'd been given about physiology that I realised I was also allowed to regret my abortion and to grieve my unborn child. And I do. My mother has also shared that she regrets not encouraging me to keep the baby, but she felt she couldn't speak, that it would be judgmental to express a different opinion. She was there with that doctor, heard no concerns, and suppressed her own questions. She felt she was not free to speak. But when mothers don't feel free to speak openly to their daughters, and professionals cannot be relied upon to speak the truth, vulnerable women like me are at risk of feeling trapped, of experiencing deep regret, and are not free to choose. A friend of mine recently called an adoption hotline for help, but was advised to call back after she'd pursued her termination options. If options are thus channeled away from certain options, the freedom to choose is certainly undermined. This lack of freedom of opinion exists for medical professionals at some times too. I have a close friend who's a midwifery student in Toowoomba. Several months ago at the base hospital, she went with a rostered midwife to help clean an aborted 21-week-old fetus so that his parents could hold him and say goodbye. As she walked into the pan room, she recalls reading "dirty utility" across the door and then seeing a baby in a pan next to a row of bins. And then she heard him gasp for breath. And again, and was deeply distressed by this. He lived for nearly an hour and a half, only she was not allowed to give him any care and had to watch him suffer as he died. She'd just finished a shift caring for premature babies, only a few weeks older than him, in the ward next door. She was told by more experienced midwives that it may be distressing now, but she'd get used to it. She believed she shouldn't share how upset she was, how much sleep she lost replaying those final breaths. She felt her grief was disenfranchised, and were she to be honest about her response to the situation, she would be at risk of losing her job or being sidelined in the workplace. It's not easy to share stories of regret and grief. It's not easy to share my story with you, but it's not a unique story. And yet, you won't hear many others shared in the public domain, and there's a reason for that. I've shared many tears with others who regret, both men and women, young and old, but most feel way too ashamed to openly acknowledge their suffering, or too frightened of the consequences of sharing a socially unacceptable pain, so they feel they cannot bring themselves to share it. But I refuse to let our grief go unheard. I feel personally that moves to legalise abortion in Queensland will lead to more stories of regret and hurt like mine. And for this reason, I can't support it as a good move for our state. I don't believe this kind of legislation really empowers or frees women at all. And if we genuinely care for all Australian women, we need to reconsider the whole issue in a genuine atmosphere of collaboration and truth. And a new law on its own will not resolve it. Thank you.
Thank you, Madeline. Our next question, I'm going to ask Cara Thomas to come and ask that question for us. Cara is a registered nurse currently working in obstetrics, and I just wondered whether she could come and ask this question, because nurses are, come up here for me, thank you. Nurses are often the ones at the coalface, so thank you so much. Martin, I'm going to direct this question to you.
Yeah. The Queensland Nurses Union has come out in support of this Pine Bill. Now, what does that mean for nursing staff like me if I don't want to be complicit in abortion procedures?
Thanks for the question, Cara. I should clarify that the questions come to me probably because my organisation, the Human Rights Law Alliance, has been approached by a couple of doctors in the last couple of months over conscientious objection issues. And these are doctors that have received threats of warnings, official warnings from the medical board for making conscientious objections to different medical procedures. So it's definitely a live issue. The framework around conscientious objection is not governed, it's governed independently of, say, the Pine Bill or any other abortion bill that comes in. So if the Pine Bill were to pass, let's say, the conscientious objection ethical codes put out by APRA would still remain in force. And the union themselves did put in their submission to the inquiry on the Pine Bill an excerpt of the policy of the Australian Nursing and Midwifery Federation on conscientious objection. They didn't say whether they supported it, they didn't endorse it, they just put it in there under a heading conscientious objection. And the substance of that policy is the same as the substance of APRA's policy. And APRA's policy essentially says that nurses, midwives and doctors do have a right of conscientious objection, but that's the only clear bit. It gets a bit murky after that. It goes on to say that it's qualified according to a few standards. The first one is you can't have a right of conscientious objection if it's life-saving care that you're administering or if it's emergency care, which, fair enough, that's a low-level exception. Another exception they make for nurses and for midwives is that you should inform your colleagues and your employer of your conscientious objection so that arrangements can be made if necessary, if a situation is going to come up which you can't be complicit in. The other one is much more vague. It says that you cannot, by conscientious objection, whether you're a doctor, a nurse or a midwife, there's two codes, you cannot, by conscientious objection, impede someone's access to care or impede someone's access to lawful medical procedures. That makes things difficult because the very act of conscientious objection in some way impedes somebody's access to a lawful medical procedure or care. And so if the right to conscientious objection exists, but also their right to unimpeded access to a lawful medical procedure exists, you have to find a middle line and find out what that looks like as a medical practitioner. We're not told specifically in the legislation, but I've spoken to some medical law experts, and it tends to be considered that if you're a doctor, you have to refer the patient to another doctor that will perform whatever procedure it is, whether it's abortion or whatever. You must refer the patient to another doctor that will perform the procedure. That way you're not impeding their access unduly, and you are not really given a right to conscientious objection because it just gives you one degree of separation. It's just by indirect act achieving the same. For a nurse, it probably means that if you're in a situation where, let's say there's a staffing issue that day, let's say that the nature of the clinic you're working in is that it's small or that it's rural, and therefore you are perhaps the only staff member there or the only one with a certain expertise or whatever the situation might be, and you exercise your right of conscientious objection in that scenario, then the imposition on the patient's access to care may just be such that you have no legal protection. Certainly it's completely uncertain. Now, those are the rights to conscientious objection as they exist under the APRA codes and as they are enforced by the Medical Board for doctors and as they are enforced by the Nursing and Midwifery Board for nurses and midwives. So they're fairly thin and they still arguably would require a doctor to be complicit, just indirectly, in an abortion or anything else. We've had 2 cases come to us in the last 2 months that show how uncertain those rules are. These 2 conscientious objection cases, neither of them were abortions, they were other matters, but in both of them the medical board wrote to the doctors, one in the ACT and one in Western Australia, to say that they were going to receive an official warning And in both cases, there wasn't really anything in the submissions given by the medical board about their right of conscientious objection. It was all on the grounds of things like discrimination. And so we've got involved in those, and the outcome as yet is uncertain. So it's fuzzy enough to be of concern. So my point would be the Pine Bill, or any other bill that purports to legislate for abortion, if it's enacted supposedly on human rights concerns for women, if those who are putting the bill forward are serious about human rights, then they need to put in the bill an unequivocal and clear statement of somebody's right to conscientious objection. And I will shortly be dealing with the issue of conscience as a right, and we'll see then how fundamental that right actually is and why it's worth protecting quite so strongly.
Thank you, Martin. Marita, you're a midwife. This microphone just there, I'm going to ask you. So as a midwife, your role is to safely deliver babies. Many of us read when you spoke publicly of the trauma that is experienced by nurses who participate in abortion procedures and see babies gasping for breath. We've heard that previously. What do you see the impacts will be if this bill is successful and Queensland decriminalises abortion? Thank you, Marita.
Thank you. Yeah, so I think that if this bill goes through, that we'll see an increase in the hospitals of this, and therefore we'll be having to deal with this more often. And that's all nice when you see it on paper, but the reality is that a government decides a thing, a doctor orders it, but the end of that line is actually a midwife who is the one executing that order. At least in the hospital where I work, it is the midwives who administer the misoprostol. And seeing babies gasping for air at 19 weeks, that is definitely true. And I have seen 19-weekers as well that have been terminated. They are complete. Now, Mother Teresa, actually, I would like to quote what she has said about abortion. She says, "There are two victims in every abortion, a dead baby and a dead conscience." And this is very true. I believe it's true, because if you see a dead baby at 19 weeks, it does something to you when you have seen that that is actually real life. It's not something you read on a paper, you're looking at it. It's looked at as a lump of cells, but the reality is that everyone sitting here is a lump of cells. We all are. We are just a bigger lump of cells. And, you know, being a bigger lump of cells does not give you the right to take away the life of a smaller lump of cells. In fact, we must protect it. So if you continue to work with this, I believe it does kill your conscience. Because you then, and when I studied midwifery, I had to learn the embryonic stages, and they have so many different names to learn all the different stages. It's a trophoblast, and then it's a zygote, and then it's an embryo, and then it's a fetus at this stage. And all those names are there to dehumanize what it really is, which is a little human, complete, and having a heart beating when a woman just finds out she's pregnant. And the effect of abortion it has on the people surrounding it, the medical professionals. I don't want that stumped off for me, but if you look at the story we heard just earlier, even of the effect it had in someone parenting with their children because they've had a previous abortion, the effects are so large. They're not, they're personal, but they're also on the professionals, but they go far beyond that. There are consequences of abortion to the nation. I really believe that history has shown that. The oldest story I know is of a country that decided that boys of a certain ethnical group had to be killed. And this is recorded in history 3,500 years ago. The midwives of the time knew they answered to a higher authority which spoke to their conscience, and they decided they would have no part in that. The government that made that ruling, that was the start of their destruction as a great nation in the time. I believe that it will have consequences on the nation, that people will not even relate back to abortion, but yet the root of why the nation is being fallen is because of the abortions that are being allowed. It will have consequences beyond you here now, the patient, the helpers. Yes, all of them will have consequences. but it will boomerang back onto the government in a different way.
Could I just quickly to add two things? We heard one comment earlier about 20% may suffer psychological harm with abortion. I think the other 80% get a dead conscience. That's one thing I'd like to say. I've often reflected on that. The other thing is 50 years ago, I remember reading through Pope Paul VI's Gaudium et Spes, he specifically, I found these lines saying the damage that abortion does to a person, but in fact, greater damage is done to the provider of that abortion. This was said 50 years ago, and we're hearing that today. We're repeating all of that.
Actually, I'm not the first one to say this. There have been people before us who have actually warned, and Ronald Reagan wrote a book, Abortion and the Conscience of the People. I have it in Dutch here, but he explains the same thing. The consequences are far greater than the immediate what we see.
Thank you. Thank you, Marita. Thank you, to Dr. Bartz. Rachel, I'm going to come back to you and talk about Women's Forum Australia. You've got a strong emphasis on research. Can you give us any evidence that you have on harm to women caused by abortion?
Thank you, Wendy. Several of our speakers have spoken about the physical and psychological impact of abortion on women, and yes, there is very strong evidence that this is the case. Countries which have mandatory data and reporting requirements, such as New Zealand, for example, record this evidence. Risks of physical complications or harm, as we've seen, include infection, which can lead to infertility and subsequent stillbirths, cervical and uterine damage, hemorrhaging, and also subsequent premature birth and miscarriage. Risks of psychological harm have been studied by people in New Zealand actually as well, such as Professor David Ferguson and his colleagues in a longitudinal study. And he's actually pro-choice himself, and he didn't expect to find any results in terms of abortion having an impact on women's psychological health. But what he did find was that abortion leads to a 30% increased risk of mental health problems for women, and these include depression, anxiety, suicidal behaviours and substance use disorders. The Queensland government itself has recognised that abortion leads to an increased suicide rate among women who seek it. And the evidence of abortion has been around for a long time. The problem is that the general public don't know about this evidence or this harm, and this information isn't often given to women who are seeking an abortion.
Yeah. So this might be something that both of the doctors might want to comment on, but I'll ask you, Anthony, first. Is there an applicable ethical code for doctors and counsellors that you follow?
So I might be able to speak a little bit more to the medical side of things, and then I guess there would be other codes around counselling that I'm not necessarily overly familiar with. I mean, interestingly, the Hippocratic Oath, which was written in I guess the Greek textbook of medicine, written in 5000 BC, he said, "I will not give to a woman a pessary to cause abortion, but I'll keep pure and holy both my life and my art." I guess more recently, and Martin's already mentioned that, we have a code of practice called Good Medical Practice, a code of conduct for doctors in Australia. And there is, as we've talked tonight, I've thought about the issue of informed consent, and that's important, I guess, that we explain to patients both the benefits and the burdens of any intervention. And I think what I've found is, in terms of practicing holistic medicine, it takes time with patients, and often these consultations may take, an hour or so to work out a really tricky issue, and then follow-up consultations. And so the challenge of trying to deliver medicine in sort of short 6-minute bursts can be problematic, I think. Now there is, and Martin mentioned this, there is I guess a standard in terms of doctors being able to practice according to their conscience. It says, being aware of your right to not provide or directly participate in treatments to which you conscientiously object, informing your patients and, if relevant, colleagues of your objection, and not using your objection to impede access to treatments that are legal. So I think that is a very important part of the code, is that we can practice according to our conscience. It does have the follow-up clause of not allowing your moral or religious views to deny patients access to medical care, recognising that you are free to decline to personally provide or participate in that care. And then finally, the AMA does have a position statement, which was first written in 1998 and then revised in 2005. It's very, I can read, it's a statement around reproductive health and reproductive technology. It does have a number of clauses about termination of pregnancy. They say the AMA respects the rights of doctors to hold differing views regarding termination of pregnancy. It's very respectful of the law, so it says where the law permits termination of pregnancy, the procedure and the associated anaesthesia should, as with any other medical intervention, be performed by appropriately trained medical practitioners in premises approved by a recognised health standards authority. Again, it says where the law permits termination of pregnancy, non-surgical forms of termination such as RU 486 should be made available as an alternative to surgical abortion in cases as where they are medically deemed to be the safest and most appropriate option based on the appropriate clinical assessment. And then finally, it is the doctor's responsibility to provide patients with information regarding the potential health risks and psychological consequences which can arise from continuation of, as well as termination of pregnancy. So that's the AMA stance.
So Anthony, you mentioned there anaesthesia. That's anaesthesia for the mother, not the baby.
That would be for the mother. Yep.
Yep. So David, is there anything you wanted to add to that at all?
Not really. I think that's Anthony summarised it very well. Only to say, and I think one of our speakers has highlighted that earlier, I think in a bigger hospital, this sort of abortion practice or termination will get channelled to a certain area. I think the crunch could come at some of the smaller hospitals where there might only be one or two doctors there and the pressure is on that, and you become a bit of a problem if you don't provide it. So I think you can hide yourself a little bit in a bigger hospital. In smaller hospitals, it's, you'll get more pressure on you, I'd say.
We're privileged to have another story tonight, and I'd love Emma to come up now. Thank you, Emma. We really appreciate you two girls coming and sharing with us tonight. Please welcome Emma.
Hello, and thank you so much for having me share tonight. I am a post-abortive victim. I had my first abortion when I was 16 years old, and I can totally relate to Madeline's story of the pain and suffering that you go through. I'm sure many women here are mums, and you know the emotions that you go through when you're pregnant, and it's a trying time even when you're going through with a pregnancy, with hormones raging and all these things going on. And people see that as a really negative thing, but I would like to see more support in that area, especially when it comes to women who are facing troubled pregnancies. I, as a young 16-year-old girl, probably like many 16-year-old girls, quite insecure, didn't know, what I was really doing, and I was just a teenager in a relationship, and unfortunately I don't remember a lot about the termination experience, primarily because I think I've suppressed it through grief and trauma, post-traumatic stress disorder, and I actually contacted my boyfriend only recently, now being married with children. I contacted him 20 odd years later and said, what happened? I just can't remember. And his dad, I think, just said this is the right thing to do and ushered us off, and that was the end of it. It was never spoken about again. And I just remember as a 16-year-old girl, I can remember right now as if I was sitting there in my typing class back when the days it was typewriters, before computers, sitting in that classroom, and it was like I was in a bubble, and everyone else was going about their business and doing, their typing and things. But for me, my world was forever changed. I was a completely different person. From the moment you walk into that clinic as a pregnant woman or a girl, and no matter what situation you're in, you're pregnant, your hormones are going on, your body's changing, your breasts are developing. You cannot ignore what is going on, and any mum or pregnant woman will know that. And you go into that clinic and you lie down and you have that anaesthetic. And I woke up on this bunk bed in a room no larger than someone's tiny bathroom. It was so sterile and so cold. And my eyes opened, and that was it. There was no more baby. There's nothing you can ever do, ever, to get that baby back. So who do you speak to? Everyone talks about pro-choice, and that's great, but people give you their advice, but they're not there to journey with you through the pain and the suffering that you have to walk through every day for the rest of your life. And that's what I went through. But because it was my choice, right? How can I then turn around and say, oh my gosh, I made the mistake of my life because it was my choice and I was empowered to do it, and people support you in it, but really you're the one that has made that decision and lives with that grief. And for me, what happened is I obviously felt that extreme sense of loss, and you would think that you would do everything in your right and power to never get yourself in that situation again. But unfortunately what happens is, and it's quite common, I understand, is that many post-abortive women get pregnant again and have another abortion and another abortion, because what you're trying to do in the depths of your soul is replace that baby. And I found myself with having had multiple pregnancies, and if you had have asked me at any stage in my journey, in my life, would you ever have an abortion again? Sorry, my mouth's really dry. There were times I would say to you, absolutely, there's no way I would do it again because the pain was so great. But then I found myself back in that situation again, reliving that traumatic experience, and it was just this horrible cycle that I just could not get out of. And who do you talk to? Because there's so much shame. Thank you. There's so much shame surrounding, I think it's been mentioned earlier, is that people don't talk about abortion. In fact, I wish that we wouldn't say abortion. Why don't we just call it for what it is and say we're killing children? I killed my children. I've killed many of my children, and I have to live with that forever. And it's the truth of it. We can talk about terminating and abortion and ending it, and it's all very beautiful. But the truth of it is we're killing children against their will, and what right do we have? What right do we have to do that? And I think, Mark, that you said it at the very beginning tonight, is that it's acknowledging the life of a human being, and that's where I believe the argument needs to come back to. It's the life of a human being, and what are we doing as a society to usher these women off to end the lives of their children when what she really needs is support? And as a woman who was pregnant, like I said many times, the last thing you want to hear from someone is, I'll just support you in whatever you want to do. As a mum, yourself you don't want that. You want someone to say, look, just put them to bed a bit earlier, or, you want some tangible advice. And when someone just throws it at you like, I'll support you, it just makes them not accountable. And as a community, we need to be accountable to these women who are suffering and helpless and turning to us saying, I don't know what to do. That's okay. I know you've got no money. Just abort the baby and go along with your life. And that's just not okay. And I can tell you the depression and the suicidal tendencies and all of those things that I have dragged with me through most of my life until, maybe 5-6 years ago. I turned into a person that that wasn't who I was. I was a healthy, really fit, anti-drinking, anti-drugs girl, and I turned into having drug dealers call me at 1 o'clock in the morning. I just led this life that was so against everything that I believed, and I just thought, what am I doing? And I remember just lying there on my couch one day, and I just said to my girlfriend, I just want to be numb. I just want to be numb. I don't want to feel this pain anymore. And I'd seen psychiatrists and psychologists and counsellors and social workers and you name it. I met with so many people to try and work out what on earth was going on with me. Why am I such a basket case? And I was. I can assure you, I really struggled. And not one person in all those professions ever said to me, have you had an abortion? Like, where are you at? And no one ever asked me. And that's not to have a go at them, but it just shows that our medical professions have absolutely no idea of the suffering that women go through, and it's not recognised. And the other side of the coin is that throughout my life, if you had have said to me, have you found that abortion has affected you? I would have said, no, not at all. In fact, no problem. This is just what you do. It's such an easy, simple procedure. I was an advocate for it almost because I was so in denial of my own pain. So it's very difficult to get research and to get statistics together, because if you ask a post-abortive woman at any stage of her post-abortive journey, has it affected you? You don't know what stage of the journey she's at, what part of the cycle. She might be coming into the grief cycle or out of it or completely in denial. So how can we ever really put a number together and statistics? Like, how can we put statistics on grief of what women's suffering is when we're not supporting them in the first place? We as a community and medical professions are actually ushering them into this tragic, life-changing experience. I would absolutely hate to see this bill being passed, because I can speak from my own experience. I just really hope and pray that other women can start to stand up and shrug off the stigma of shame that comes with abortion. I'm so glad now I have this freedom to talk about it, because I'm really righteously angry about it. But I'm also really hurt as well, because there's so many facets to this argument. You know, there's the woman who's pregnant, there's the child that just doesn't have a voice. Like, I don't know, it's great that it's a woman's argument, but hang on a minute, let's bring it back to the life of a human. And it also affects parents and spouses, like the relationship with my mother, you know, the guilt that she carries. Why didn't I support you? And I think someone else mentioned the same thing, that they didn't really have a voice from their mum, or the doctors and nurses. And my mum has got grandchildren that she will never see now, you know, and what she carries, and my siblings, and it affects the community as a whole. And when it does absolutely affect mental health, that does put pressure on our government. And I would just love to see Australia and Queensland rise up as a nation and a state to be supportive and to help the women in our community, so that we can have other countries come to us and go, wow, what do you guys do? You guys rock. You have got such a powerful support for women, and you've got so many systems in place that really help each other, instead of just killing and having that killing mentality, you know. And I did see something on Facebook, dare I say, that it had a real feminist would actually stand up and fight for the right of a woman in utero, you know, and I just was like, wow, that's incredible, you know. And we say it's pro-choice and supporting women, but really, what about the woman, the young girl, the child in utero, you know, and let's fight for them. So I think that's about it. But yeah, thank you so much for letting me share. Cheers.
Thank you, Emma. Martin, I'm going to come back to you now, please. Martin, what conscience rights currently exist in other countries? So Emma was just saying, let's get Australia to be the one who rocks. Yes, I love it. What conscience rights currently exist in other countries, particularly European countries? And is the move to remove conscientious objection rights from Queensland doctors in line with other countries? And I guess, is it a progressive move that we're looking at here with the Pine Bill? Yep.
Sure. Can I subvert the process and answer two questions in one?
Absolutely.
Because the next question is about what international human rights are relevant.
Yes,
and I can answer that as well now, because conscience is an international human right.
So my second question to Martin was, what international human rights are applicable and what do they say? And can you tell us if there are any relevant human rights cases which have occurred here in Australia? You might have already said some of that. Thank you so much.
Yeah, sure, we have, yeah.
That's great.
So I'll answer all of that together, because the right of conscience is an international human rights issue as well as a domestic human rights issue, as are some others. In relation to what's going on internationally, particularly in European nations, as Wendy said, I think a lot of us will find the legal frameworks around abortion in particularly Western Europe, which is widely considered the most progressive part of the world. I think we're very surprised to see what the laws there actually are. So just for interest's sake, I thought I'd go through some of those jurisdictions and just say what they are. In Germany, for example, there is a compulsory waiting period of 3 days for any woman who wishes to procure an abortion. There's mandatory counselling that's mandated for every woman. That counselling, it says in the regulations, must be directed at saving the life of the child. And it must be counselling provided independently of the medical practitioners. Also, abortion is only permitted in the first 12 weeks without limitation. although you still have to do the counselling and you still have to have the cooling off period. But after 12 weeks, a whole lot of very burdensome limits come in. And you can only have an abortion after 12 weeks in cases where there's a very narrow exceptions. It's to prevent grave danger to the mother's life, injury to her physical, mental health. And there is a conscientious objection right in Germany for doctors. In Belgium, the waiting period is 6 days. And that's applicable from the time of the first doctor's consultation. Again, abortion is only permitted without further restrictions up until 12 weeks. After 12 weeks, it's only available on grounds of a risk to the life of the mother or a severe and incurable fetal abnormality. And 2 doctors have to verify that. There is a mandatory follow-up appointment 3 weeks after the abortion for the woman to attend. A doctor is required by law in Belgium to inform patients of alternatives to abortion and the risks of abortion. In France, again, an offer of counselling counselling is not compulsory, but it is compulsory to make an offer of counselling to any woman who seeks an abortion. Again, only permitted for any reason up to 12 weeks. That counselling is mandatory for minors, and it must encompass marriage counselling, family planning counselling, and social services. The doctor is required by law to inform the patient of alternatives to abortion and the risks of abortion. Again, conscientious objection available in Belgium, conscientious objection available in France, although in France they must refer the patient to someone else. In Denmark, again, only available up to 12 weeks for any reason. The absolute upper limit in Denmark and many of these jurisdictions is viability, which varies between 20 and 24 weeks depending on the country. But between 12 weeks and the viability, it's only because of rape or incest, mother incapable of caring for the child, serious and unavoidable burden. So there's specific grounds on which it can happen. But there is a panel of 4 members that must verify that those facts apply to each case, and it must be a unanimous decision of 4 members of the panel to secure an abortion after 12 weeks. Again, conscientious objection is available in Denmark. The Netherlands, there's a waiting period of 6 days, applicable after the first doctor's consultation. The doctor is required by law to inform patients of alternatives to abortion, the risks of abortion. There is an upper limit of viability, which is 24 weeks in the Netherlands, except on the grounds of fetal abnormality. And, of course, the risk to the life of the mother, conscientious objection applies, and so on. In Poland, you've only really got first 12 weeks of abortion is permissible. After that, it's on very narrow grounds, risk to the life of the mother, incurable fetal abnormality, rape and incest. Austria, again, first 12 weeks, thereafter, severe restrictions. Even in really progressive places like Norway, it's only up to, well, it's any reason up to 12. Then between 12 and 18, certain grounds have to be established. After 18 weeks, it has to be extraordinary grounds, normally a threat to the life of the mother, and the doctor is still required by law to inform the patient of risks of abortion. And that's not considering the outliers like Malta and Ireland, where abortion is not lawful. So that's what's going on internationally. I mean, in New Zealand, again, there's only certain grounds it's allowed, and also it's still part of the criminal code if abortion is procured outside of those grounds. So people talk often about America, where we had Roe versus Wade. They talk often about Canada, but they very rarely talk about Western Europe on this particular issue. And the stats, the information in that regard is very surprising. We talked about, there's a couple of things have come up in relation to all of this. One is the conscientious objection stuff, and one is, as Mark mentioned before and has come up again, is the right to life stuff. These are they've got the status of international human rights. Not all rights are international, some are domestic as well. That's one of the unique features of our system. We've got a common law system where there are some rights in our common law. One might be led to ask why it is that these human rights are relevant. The reason they're relevant is that human rights have been devised as a series of principles that ought to limit the power of government. And here we are talking about changing a law or reforming a law, and so straight away it comes into play this issue of whether or not the government could be overstepping some of these limits that have been derived through human rights law. Some of those limits came up through common law, which came through the English system, came to Australia, we've developed our own. Things like free speech are in the common law, things like a right to fair trial, presumption of innocence, things like that. And England and Australia had a great history of human rights, but Then, of course, there's another source of human rights, which is international law. And that really has come about because, particularly following the First and Second World War, the world sort of sat down and said, we need to stop atrocities from happening. We need to put together some principles that all nations can sign on to, which will protect human dignity and which will protect fundamental rights, so that the atrocities that we've seen for the last 2 world wars and the intervening period can be stopped. And the International Covenant on Civil and Political Rights was written in that context. And you can therefore understand why in the International Covenant the first right that is given is the right to life. It's the first one that appears, because it was really the eugenic impulse that was underlying so much of the atrocity that went on. And states could not arbitrarily deprive any citizen of life. Another right which is given huge importance in the International Covenant, that is, it's actually a non-derogable right, one of a very small number of non-derogable rights under Article 4. And a non-derogable right is one that cannot be derogated from, cannot be diminished even in times of national emergency. And that's the right to freedom of thought, conscience, and religion or belief. That's because the realm of someone's mind, their conscience, is the last bulwark against the reach of the state. If the state reaches into your mind and says how you should think, how you should believe, and what your convictions should be, you're in real trouble. Your mind is sacred. Your belief and your conviction is sacred. And that's why Article 18 is given such serious prominence. I mentioned the right of conscientious objection. One of the few European nations that doesn't permit conscientious objection is Sweden. And it's interesting because right now there's a case coming out of Sweden that will be heard in the European Court of Human Rights. And it's a midwife who conscientiously objected to performing an abortion and lost her job. That case is able to be heard in the European Court of Human Rights because the European Convention is based on the International Covenant and it has that right of conscience. And so you have there a source of international law that says, no, the conscience is still sacred for the same reasons we said it was sacred following atrocities in the past. When it comes to the right to life or a right to abortion, very strangely, a lot of human rights lawyers on the other side of the fence philosophically with this issue, they go searching through mountains and mountains and mountains of international soft law, desperately trying to find something to hang a right to abortion on. But in going after the obscure, they avoid the obvious. And the obvious is that the first right given in the ICCPR is the right to life, and it appears in Article 6. It says, and it's been read, but I'm going to read it again just because it's so important. It says, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. And then skip down to subclause 5 and it says something very interesting. It says, the sentence of death shall not be imposed for crimes committed by persons below 18 years of age and shall not be carried out on pregnant women. So firstly, it establishes a ceiling, not a floor. 18 years. No minimum. And then it says that this shall not be carried out on pregnant women. And in the preparatory statements that were made in the lead up to the drafting of the ICCPR, which are often used to get interpretative context, we read this, and this was in the UN General Assembly session in December the 6th, 1957. They said, the principal reason for providing in paragraph 4 of the original text, well, for providing paragraph 4 in the original text, was that the death sentence should not be carried out on pregnant women to save the life of an innocent unborn child. There it is, and it's in the explanatory statements on the first of those articles. Another very prominent international law instrument is the Convention on the Rights of the Child. That convention is also signed and ratified by Australia. It's one of the conventions our Human Rights Commission is supposed to be custodian of. The preamble, which the Vienna Principles for the Interpretation of Treaties say must be used to interpret the context of the entire treaty. The preamble says this: the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. And then Article 1 says, for the purposes of the present convention, a child means every human being below the age of 18 years. Again, a ceiling, not a floor. And Article 6, states parties recognise that every child has the inherent right to life. States parties shall ensure, to the maximum extent possible, the survival and development of the child. Again, in the interpretative context of before and after birth. And Mark pointed out the Victorian Charter of Human Rights, it has that clause that says nothing here derogates from any of the laws on abortion. Why? Well, the lawyers clearly advise that it may be invoked against abortion. So given the context of these human rights, the importance of them and the fact that we've all signed up and we've ratified it, it is a concern about the direction of this law, both in terms of its attack on conscience and also its attack on life. It's not progressive, as Wendy said, it's definitely regressive, because it's going back to something we said would never happen again. And I think we're on the side of human dignity.
Thank you so much to all of the panel. I'm sorry we're not going to have time for questions from the floor. I was hoping to. I'd like to just have a few closing comments. But if you have questions that you would like to direct to any of the panellists, please send them to me, because I know that they will want to answer them. They are here because they care deeply about this issue. There are a number of things that you can do, and we have some information for you in the program for tonight. You will see that there is going to be a rally outside Parliament House next week. That's next Tuesday at around lunchtime, but the details are in your program. The other thing that I would really like you to all take from here tonight is we have a little booklet, a number of pieces of paper here that are stapled together, and it's Changes to Abortion Legislation Information Pack. In that you'll find a lot of information about the proposed changes, but also what we would like you to be able to do is to actually conduct a letter writing campaign to your MPs. We have the addresses in there. Handwritten letters still are really important. They show that you really do care, but there's also the ability to email as well. But this is something that our MPs are really wanting to hear from you, from both sides of the main parties and certainly from a number of the smaller parties and the independents as well. They want to hear, they need to hear, and we need to let them know what we're thinking. We really do. So please, a number of people are handing these out now, so you'll be able to take one home. Really appreciate you paying attention to that and doing all you can to actually participate in this conversation. It's probably one of the most important conversations I can remember in the time that I've been working with the Australian Christian Lobby. I just want to say thank you again to the panellists. Could you please thank them for me? These are extremely important people, and I'm just glad that no babies were born during the... No babies were born. Oh, no, he's looking a bit sheepish. Maybe there was. Please apologise to that mother. Yeah. We're really grateful to you for coming, and I am thankful to each of you, because I know these are very busy people, but you are as well. So thank you very much. God bless you. Thank you.